So welcome everyone to the second session of our ASLI conference today. I'm Dennis Khong and I'll be the session chair for this session. And for this session, this will be the keynote session, and we are very happy to have Shubha Ghosh from Syracuse University to talk about antitrust in the hipster economy. Just a quick introduction to Shubha Ghosh. Shubha Ghosh is a Crandall Melville Professor of Law at the Syracuse University College of Law. He is the director of the Intellectual Property and Technology Commercialization Curricular Program and also the director of the Syracuse Intellectual Property Law Institute. And today he will be speaking to us on antitrust in the hipster economy. So we will have about 45 minutes to an hour for a presentation. And after that, we will open to everyone to have your questions. You are welcome to type your questions in the chat box, and we will be able to respond to that orally. And we hope that at the end of the session, we will invite everyone to turn on your webcam so that we can have a group photo for our records. So let us welcome Shubha Ghosh.
Thank you, Professor Khong. It's an honor to be asked to be on the keynote for this lovely conference. I wish I could attend in person. We wish we could all see each other. Hopefully next year when we have things under control. But I've followed the Asian Law and Economics Association for many years. I've been in touch with Dennis, whom I met. I think for the first time we met in Italy, I think back in 2004 or 2005. And so it's been wonderful to see Dennis's work and see it progress. So thank you, and I hope we can have a good presentation as well as a good discussion. I'm going to talk about antitrust in the hipster economy. Antitrust, of course, is what we call in the United States competition law. We can have a discussion about this comparative aspect of competition law. How does antitrust compare with competition law in other jurisdictions? And we can also discuss how competition law deals with how antitrust law in the US, I was checking the chat real quick, how antitrust law in the US fits into broader competition law principles in the United States. And some of those concepts I'll talk about today. But what is this notion of the hipster economy? That might be a very strange concept to many people or an unfamiliar one. And so, let's see how I move to the next slide. I guess I do it here. Okay. So in the United States, we've had the phrase hipster antitrust that was used by a person in the Trump administration, Attorney General Jeff Sessions, about 2 or 3 years ago, to talk about work that's going on in antitrust law that was motivated by a scholar, Lina Khan, who is now a professor at Columbia Law School in New York. And Jeff Sessions used this phrase, hipster antitrust, very disparagingly. The idea behind Lina Khan's work is to look beyond just simply welfare maximization or consumer surplus maximization as the criteria for antitrust policy, and to look at probably other constituencies and other metrics for determining when antitrust policy should be pursued. And so this was dismissed by traditionalists as just hipster antitrust. But I want to suggest that really, what we're thinking now with works like Lina Khan and some of the recent lawsuits that were brought against Google, just yesterday, the lawsuit brought against Facebook, and various other cases involving high technology, is that it's not so much hipster antitrust, but a hipster economy, that the nature of the economy and economic relationships are what is changing. things like platform, things like networks, uh, things like various types of contracting practices, is really the economy that's shifted. And competition law principles, antitrust, may still be fairly traditional in some ways, but it has to adapt to the new economy and to the various aspects of what I'm thinking about as the hipster economy. So what do we mean by hipster? This is a term of art in the United States. It traces it, the term traces it back to the 1950s and the 1960s for the counterculture in the United States, and sometimes associated with the beats, which is on the right-hand side here, or the beatniks. There's so many different dimensions to what beat or beatnik means, but it gave rise to what we think about as the hippie culture in the 1960s. But the basic idea behind the beats and the hippies were that they somehow had special knowledge, that they somehow had, by looking internally, by looking at things spiritually, a better knowledge of the world. And then the term in the 1990s gets some sort of revamping as the term hipster. And to show you on the left side, this field guide to different types of hipster cultures. I can share my slides if people want to learn more about my field as well as about hipsterness by looking at the slide in more detail. But in the 1990s, you know, this whole notion of the spirituality of the beats and the hippies took on a material and a consumer bent. And so the hipster may have had very much consumerist, materialist values, but the materialism or the consumerism was something special, was based upon special knowledge or based upon some special understanding of commodities, of artisanal products or of music or of art and so forth. So when we're thinking about the hipster economy, and I think I like the term hipster economy, we're reflecting the fact that the economy, especially when we're thinking about the information-based economy, has made a major shift from when we are thinking about the time of the railroads, when we're thinking about the early years of the newspapers, the early years of the automobile industry, the airline industry, where we were thinking about large-scale industry, economies of scale and scope mattered quite a bit, as opposed to the economy now, which is largely based more on networks, more on sort of individual niche type markets, hipster markets, in other words. And so that's what I'd like to explore. In my talk today, I want to think about developments in antitrust law in light of the hipster economy. And my talk will have basically three parts. The first part is to lay out this theory of antitrust in the hipster economy. And then I will go in to look at several examples. And I have a few examples in the slide. Depending upon timing, if we have time, I might add some examples that will go off slide to discuss. But the two examples I will talk about involve the concept of exhaustion or aftermarkets in antitrust. And there we'll explore the interactions between intellectual property and antitrust law in some detail. And then I will talk about the Google case, the various cases against Google that have occurred in the last decade, as well as the current case that was filed against Google in October of this year by the Department of Justice. And we'll use those two examples, and as I said, if we have time, some more, to talk about, how does antitrust work in this new environment that I think that we're in. So the main references I provide are some work that I have on natural monopoly and intellectual property from 2008. My book with Richard Gruner and Jay Kissan. Richard Gruner is at University of Southern California. Jay Kissan is at University of Illinois. deals with intellectual property, but from a transactional standpoint, and delves into some of the antitrust, as well as some of the contract and transactional issues that arise from intellectual property. And then many of the thoughts and ideas are drawn from a recent book by Richard Gilbert, Innovation Matters, Competition Policy for the High Technology Economy, which is a very thorough, very up-to-date book about antitrust cases against technology companies. It was a book that was published earlier this year by MIT Press. And I'll drop a couple of other sources as we proceed in this discussion. So let me begin by talking about theory and policy. And we start off with this famous graph of the inverted U that talks about the relationship between competition and innovation. And so this reflects the theoretical divide between the work of Joseph Schumpeter and Kenneth Arrow. Joseph Schumpeter talked about capitalism as developing, as innovation occurring within the capitalist system through creative destruction, which involved companies getting large in size, enjoying economies of scale, as well as economies of scope, and therefore developing the rents needed to engage in innovation. And through this innovation, we have the process of creative destruction, whereby old technologies, old markets, old ways of structuring the economy have shifted and moved to other ways. So Schumpeter, to look at this inverted U, and if you look at R&D expenditure and so forth, as we move towards less competition, towards the right here, you'd have more innovation. You'd have, as one measure of innovation, and we'll talk a bit about how you measure innovation. But for example, if you're looking at R&D expenditure as a percentage of sales, then as you have less competition, starting out from a point of zero concentration, you would have increasing innovation as measured by R&D expenditures as a percentage of sale. Arrow, however, Kenneth Arrow, really looked at competition as the basis for innovation. That in order to have some sort of disruptions in the marketplace, you have to have the entry of new firms, you have to have the entry of new ideas, and these in turn result in new products, new methods of manufacturing, new services, and that then becomes the basis for innovation. So that as you have less competition within the Arrow model, the incentives for innovation fall, and the measure of innovation as R&D expenditure as a percentage of sales then also begins to fall. And that then creates this negative relationship between the amount of concentration and innovation within the marketplace. So Schumpeter and Arrow, Schumpeter would suggest that there is this a positive relationship between concentration and innovation, and he would probably believe, though there was not that much empirical work, that to the left of the maximum point on this graph is really the best description, and he may not have viewed this as a linear relationship, but he would not necessarily point to an inverted U. And similarly for Arrow, the right side to the maximum point really is the nature of the relationship, where you have more concentration leading to declines in innovation. If you look at some of the theories and try to combine Schumpeter and Arrow, it may be the case that if you have no industry. So if you think about the railroads, you think about path-breaking innovation, that may require some degree of concentration for these types of path-breaking innovation to occur. But once you try to look for developments, within the path-breaking industry, once the industry has become, if you will, normal and disseminated, then at that point, competition is desirable in order to maintain some innovation in that industry. So here, looking at railroads might not be relevant. If you look at, for example, the transportation sector, at some point, if you're thinking about just starting off with only railroads as offering the means of transportation, then increasing concentration among railroads can lead to the railroad industry. But if you start having very strong concentration in that industry, the railroad industry might then try to disrupt or forestall, for example, automotive transportation or airline transportation. And you need to have the competition that arises from these new technologies, new modalities, new industries, new firms that are providing new types of services to promote the necessary innovation. So there are many stories we could tell about this. We could tell a story about pharmaceuticals that, for some path-breaking drugs, you need some degree of concentration. But then if you're trying to think about innovations in the dissemination of a drug, then more competition might be necessary at some point within the industry. If you're thinking about information technologies, creating path-breaking technologies in telecommunications might require some degree of concentration, but afterwards they are there's need for more competition. Now, I haven't said anything about industry structure. Again, this is something that I've talked a bit about how you'd measure the y-axis and some of the controversies. There's of course controversies as to how you'd measure the x-axis. Here, very crudely, we're looking at concentration ratio, but we could ask the question in terms of market structure. What would the market structure be? Schumpeter was thinking about, monopolies, or at least fairly concentrated oligopolistic markets. Arrow, at least in the stylized model that he had in his paper on innovation activities, seemed to be thinking about a perfectly competitive market, but his story would also be consistent with a fairly competitive or less concentrated oligopoly market as well, or a less concentrated monopolistic competition market as well. So the market structure story is something that is also worth exploring, and that's largely a question of how we're gauging concentration within an industry. So there's lots of recent scholarship looks at the various ways in which we think about these results, and this is from Gilbert, some of the summaries of major papers about the relationship between concentration and innovation. One way to measure innovation, as I've suggested, is R&D. That's again troubling how you measure R&D and whether it actually captures innovation or not. Another measure, of course, is to look at patent counts and patent citation. Another way is to look at things like entries of new firms. And so these various studies look at various measures of concentration, as well as measures of innovation. And you see that the studies are somewhat all over the place. They seem to, if you're trying to do a meta-analysis, suggest that at some point more competition is desirable for innovation. Again, then moving to the point about antitrust, suggesting that antitrust enforcement or competition law policy enforcement is desirable for innovation. But if you look at, for example, the Blundell study from 1999, you see that lower concentration leads to more patents. The Agion study in 2005 does find evidence for an inverted U shape. Again, we see sort of an inverted U shape suggested by the Agion study of 2009, where they tried to look to see how far an industry is from the technology frontier. You see in the Bloom study that competition is positive related to measures, but you see no relation to entry from developed countries other than China between the measures of research and development and innovation that they used. When you look at R&D as a measure, again, in the Gutierrez and Philippon study, you see that competition is positive related for industry leaders, but for laggards, in the industry, we don't see any type of competition as having any effect on innovation for also RANs, non-industry leaders. And then in the Autor study from 2020 that looked at patent citations and R&D and then tried to look at Chinese import activity, they found that competition as measured by the entry of Chinese imports was negative related with the innovation measure. So this is a summary of some of the studies. If you look at further refinements, you see things involving research and development races, issues involving durable goods, and then more careful discussion of innovation based upon incremental and compared to drastic innovation. And so for R&D races, Lerner suggests that technology laggards in the market for high density drives innovate more than leaders. Igami, 2017, new entrants in market 3.5-inch drives invest more than incumbents. When you're looking at things like durable goods and whether you see investment in the creation of long-term consumer goods, Gettler and Gordon found that in their study of Intel AMD duopoly, they found a duopoly in the microprocessor market that found a basis for some suppression of innovation. And then finally, when we look at incremental and drastic innovation, the Cohen 2010 study found that larger firms pursue incremental innovations, especially with respect to process improvements. So there's a lot of interesting research, a lot of very subtle stories about how innovation and competition interact. And this again suggests that what we think about as the modern economy that's based on high technology across various sectors, the information sectors, the hardware sector, the pharmaceutical sector, we see a very complicated dynamic about market forces and innovation. So, looking at the pharma studies, we find, for example, that pharmaceutical mergers leading to lowered R&D, suggesting that concentration and innovation are negatively related. Danzen found that merging pharma firms did not behave differently in R&D than non-merging firms when controlling for factors that lead firms to merge, such as number of marketed drugs, patent expiration, and pre-merger value. You see again in the HOCAP study a reduction in patent post-merger in the pharma industry. Again, Grabowski, merged firms tend to move more often to phase 3 trials in terms of getting FDA approval. The Cunningham study found that pharma companies more likely to terminate drug research projects acquired from other companies compared to ones they originate themselves. So again, a very mixed story in the pharma sector. One interesting aspect of competition and innovation is the role of compulsory licensing. So what if you adopt a requirement in technology sectors that new technologies have to be licensed? So this can be thought of as some sort of essential facility type theory, or some sort of theory of potential competition. what is the experience? Again, we'll talk a bit about this in some of the cases, especially the Google case, and it comes up in some discussions even involving the Microsoft case. But there is a split, of course, about how we view compulsory licensing. Um, uh, Lena Khan and others have opened up the debate about compulsory licensing. In the US, compulsory licensing has often been viewed as a extreme remedy, something that is not desirable. In general, US antitrust law rejects the essential facility doctrine, at least in the same terms that they exist in the European Union and in other jurisdictions. But nonetheless, we do see some very interesting examples of compulsory licensing. AT&T in the US was ordered to license its existing and future patents royalty-free. IBM ordered to license patents at time of 1956 decree on non-exclusive royalty-free terms. Xerox was ordered in 1975 to grant licenses on patents relating to plain paper office copiers. So the question is, whether these compulsory licensing obligations were effective. There's question about whether it was effective in the AT&T and IBM situations. In fact, there's an argument to make that in the IBM situation, that compulsory licensing may have hurt the company. And of course, with AT&T, the story gets very complicated, especially because of the company being divested in 1984 and various aspects of the research wing of AT&T with Bell Labs splintering off in different directions. But Xerox did lead to new entrants in the photocopier industry. And so, again, the story is very complicated in terms of how compulsory licensing stimulates innovation. This is sort of the story that we're seeing. And against this, we can think about some of the stylized facts regarding what I'm thinking about as the hipster economy and the way we think about antitrust and competition law within the hipster economy. So, one example of this would be, to think about the various stylized facts. And I'll just go through these and then we'll look at certain case studies, the Exhaustion case study and the Google case study, to illustrate these in more detail. First stylized fact is that innovation can disrupt industries and complicate predicted effects of antitrust enforcement. So this is something that, often comes up in the debate, especially when we're thinking about antitrust entry into the market. Markets are unpredictable, and we sort of see that I summarized in the previous slides. And because of those unpredictability, because of innovation as a process that works alongside competition, in sort of a symbiotic relationship with competition, it's very hard to predict where markets are going to go, where industries are going to go, and therefore how to exactly target antitrust enforcement. Most high-tech industries have high entry barriers. And so if we are trying to think about competition in these industries, we need to deal with these barriers and the source of these barriers. Do they arise from what we think about as a natural monopoly type situation? Are they artificial legal barriers that might come from regulation or from excessive intellectual property law or poorly defined intellectual property rights? Many high-tech industries have network effects that can entrench incumbents. And we'll see the discussion of network effects, especially in the Google case. The question is whether these network effects, because of the positive externalities that they generate, should allow us to tolerate some degree of concentration in high-tech industries and caution against antitrust enforcement. Or to put it another way, how should antitrust enforcement deal with the fact that there are network effects that are beneficial in high-tech industries. Fourth stylized fact is that many firms in the high technology economy are platforms that serve populations with different price cost margins. So here we see this a little bit with Google, but I think a better example here would be Amazon. And we are now seeing some action against Amazon in the EU. And there's discussion about whether there will be some action against Amazon in the United States. If I were to make a prediction, I would think that the new administration, the Biden administration, might go after Amazon at some point in time. Again, we can talk a little bit about that. But the Amazon example as an illustration of platforms for many reasons. One is that Amazon does provide the platform on which retailers can sell their products, but Amazon also operates on that platform competing with these retailers. So that it's not only in a vertical relationship or a complementary relationship with retailers, it's also in a competitive relationship with these retailers. So the question is, should those be separated? Should a firm be either a platform or a competitive retailer or a competitive wholesaler? Professor Khong has made the case, among other points that she's made, that those should be separated. Her Yale Law Journal article from a few years ago about Amazon's antitrust paradox was precisely making this point, as well as others, about how antitrust should deal with high technology firms like Amazon when they are both in this complementary relationship, a vertical relationship, and a competitive relationship. Now, what makes platforms a little more interesting is that they often arise in two-sided markets. So what platforms do is provide an intermediary or middleman function by coordinating two sides of a market that need to be matched. So here again, we wonder about, what isn't a platform? There's a lot of discussion about those among some scholars who actually question whether the notion of a platform is really meaningful. If you go back to any industry, platform, any industry has some dimension of this platform. If you think about railroads, for example, railroads provided a service that they were engaging in, but they also provided a matching function between those who, for example, wanted to distribute a product and those who wanted to obtain or receive a product. So the railroads, any sort of transportation firm has some distinctions or some elements of a platform. But I think it's important to distinguish between things like transportation costs, where we're thinking about a cost of production, and the information costs that we're often seeing in these high-tech platforms. So one of the things that we're seeing, for example, in Amazon, is that it serves a matching function. It's not just simply identifying buyers and sellers. It's also trying to figure out, the tastes of individual consumers and match them with the capabilities of individual suppliers. So Amazon often operates also in very niche markets and trying to identify those niche markets. And so Amazon is not just simply providing a middleman function of selling, like a shopping mall or if an office building does. It is also providing an information coordination function among populations that have different price cost margins. And we see that again, for example, with Google. We'll go into this in a bit more detail when we talk about the Google case. But Google, is a platform because through its search facilities, what it is doing is trying to economize, help individuals economize, and we can think, specifically about consumers in their search for products. So partly what Google is doing then is making this matching from consumers who are seeking products and sellers who are seeking to provide various types of products and services. And without Google as the platform, this information matching would be a lot more difficult to do. And so, Google's benefit is in providing these platforms, and then how you structure the platforms, how you price it depends upon the various price cost margins of the supply side and the demand side in the market, the two sides that have to be matched in the marketplace. And so Google has to price accordingly. And as a platform, it has to deal with the information externalities that are at issue in this matching function. And then it also serves a more traditional middleman function or intermediary function that you might see with transportation facilities or shopping malls or office buildings. So the fourth stylized fact is probably the most interesting for what I'm thinking about as the hipster economy. It really does require us to rethink the ways in which markets operate, as well as the way in which antitrust should respond to these new types of economies and these new types of economic challenges. Okay, so look very quickly at the last three stylized facts. Information is critical for the high technology economy. Complements, interoperability, and standards require different approaches to evaluate competition. And many high-tech firms have a low cost to integrate into new markets and exclude competition, so that the competitive dynamics are very different when you're looking at high-tech firms. So the last three stylized facts are relevant for examples that I don't think I'll have time to talk about, but they arise, for example, when we're looking at cases like Qualcomm, cases involving patent pools and standard setting organizations. They're relevant for some of the issues that are arising in the Facebook case. So for example, if you look at the last stylized fact regarding high-tech firms being able to integrate into new markets and exclude competition, at the heart of the Facebook case in the US is Facebook's acquisition of Instagram, and the view that over time that merger that was deemed to be acceptable under the antitrust laws has become anti-competitive. And so that has raised some controversies in many ways about whether you can undo a merger after almost a decade. It's actually been about 8 years. And what's the basis for undoing the merger? How do we understand exclusion of competition in situations where firms can move so quickly? So that's the theory and policy. Let's look a little bit at competition law enforcement in two examples. And the problems that come up again in the way we think about antitrust law applying to the hipster economy is one of market definition, one of potential competition, one of how we understand efficiencies, especially the problem of appropriability, and then the evidentiary burdens. Who should have the burden to prove what in these types of environments? So let's look at the case of exhaustion. I like this case for a reason that you'll see in a minute, because I've recently completed a book about exhaustion. Actually, it's about 2 years old now, the book. And I'm doing some more research in this area. It's an active area of research for me. But it's a nice area where we're seeing an intersection of technology, antitrust, and then intellectual property. So very broadly, exhaustion is a limit on intellectual property rights. It's a doctrine within intellectual property law based on theories of implied license. And so the basic idea is when I buy something that's patented or copyrighted, I have an implied license to resell, and I also have an implied license to repair. And so here we see an intersection of intellectual property and competition law. We think about problems of restraints on trade. We think about how intellectual property rights give way to contract rights. And looking largely at from a market perspective, we're thinking about aftermarkets and post-sale restrictions. So the exhaustion doctrine is often also referred to as the first sale doctrine. Sometimes it's referred to as the right to repair. But the basic idea is that exhaustion is a doctrine that allows for competition in aftermarkets by trying to put some limitations on post-sale restrictions. So in the Quanta versus LG Electronics case from 2007, you had LG Electronics that held process and product patents on technologies used in microprocessors. LG licensed Intel to use the patents to make microprocessors. Intel then sold the microprocessors for installation in personal computers. Quanta bought the microprocessors from Intel for installation in computers combined with other non-Intel and non-LG components. LG sued Quanta for patent infringement. So basically, when Quanta was combining the Intel, the LG protected microprocessors with non-Intel and non-LG components, LG was saying that that was an unauthorized use of those patents and therefore patent infringement. So Supreme Court rules that LG's patent rights had been exhausted in its transaction with Intel. Patented technologies had one intended use, and that was the one implemented by Quanta. So Supreme Court ruling was based on competition law precedent. It looked back at a case called Univis Lens from the 1930s. And in this way, what the Supreme Court was doing was grounding the exhaustion doctrine in competition law principles. So what are the implications of Quanta? US Supreme Court applied Quanta ruling to find exhaustion in Lexmark's marketing practice of controlling resale and reuse of printer cartridges in a 2014 case. And very recently, Qualcomm based its no license, no chip policy pursuant to the Quanta ruling. So the big issue that's coming up with exhaustion from a competition law perspective is competition in aftermarkets. And aftermarkets are very important in the hipster economy. When we're thinking about technology, we're thinking about technology that has some durability, technology that can be reused, refashioned, and often this reuse and refashioning occurs in aftermarket, so after the product is initially sold. So one example of aftermarkets is the market for used products. Under the exhaustion doctrine, a purchaser of a product protected by intellectual property can resell the product without having to compensate the intellectual property owner. So the resale market can apply discipline to exercise of market power by the intellectual property owner, and it does so in various ways. Used good market provides competitive pressure on the primary market. Product differentiation, however, can limit competition from resale. But there is some consumer benefit from product differentiation that might, in some situations, make up for the limited price competition. Furthermore, there's reducing durability of the primary product, which is generally a bad thing from a perspective of competition. And so this can occur through versioning. So for example, evergreening in pharmaceuticals is an example of this versioning. We can think about this in the world of case books, changing various editions of the case book by just simply slightly adding new cases or changing content. So requiring students to buy a new version, even though it may not be that much different from the old version. And so you see this again in software, where you might see updates, where the updates may not actually add that much more functionality, but do allow for upgrades by consumers. You also might have damaged goods. So you might have products that are designed to only last a certain amount of time. This also is a situation which can reduce the durability of the primary product and can counter the value of having a resale market. But when we're dealing with these other variations, this is where we need to think about the service market. So one other aspect of aftermarkets is the service market, and there's lots of litigation regarding service markets. And so these cases involve the intellectual property owner who tries to limit competition in the service market by creating authorized service providers. And for these authorized service providers, the intellectual property owner might license any necessary patents and copyrights, but then at some point refuse to deal. Or they might have tying arrangements where the purchaser of, let's say, a product that's protected by patents or copyrights are required to service the product at particular outlets, therefore tying service with the product. And so this is where we have a very interesting debate that's happening in the area of competition law and intellectual property involving the right to repair. Should then consumers have a right to repair as a check on intellectual property law? In other words, they already have a right to resell. Should they also have a right to repair? How broad is it? So there are some interesting cases that have recognized the right in some very limited ways under patent law. And there are many statutory reforms to recognize the right to repair as part of this technology economy. And so one of the big issues in this is the use of technology protection measures that make it very difficult to repair, let's say your smartphone or an automobile or a printer. And this raises the question of technological ties, which has been a big issue, for example, in the Microsoft case, and is coming up a bit in the Google case as well, as we'll talk about. Related to this issue of right to repair is the market for spare parts or replacement parts. And so intellectual property owners have sought to limit the spare part market, again, by only having authorized parts. They do it by designing the spare parts, or they do it by having a particular design for the product itself so that only certain parts can be used with them. So this then raises the question about whether you can reuse the spare parts under the exhaustion doctrine, and then whether there might be a broader right to repair that would allow consumers to access these spare parts in order to be able to exercise their right to repair, despite some of the impediments imposed by the intellectual property owner. And so some of these issues I talk about in my book, Exhausting Intellectual Property Rights, co-authored with Irene Kaboli, published by Cambridge in 2018, which talks about these issues as well as more generally how we think about competition law in the technology sector. Dennis said I could go for about an hour or thereabout. I have about 10 to 12 minutes left, so please let me use this time. Yeah, Dennis?
Yeah, you have all the time.
I have more time?
Yeah.
Okay. Okay. Well, I would like to have some questions and discussion as well. So, we'll hopefully we'll have time for that. So let me close this. So the case study that we'll look at involves Google. So let me spend some time talking about Google without taking up too much time, but I will go into it in some depth, and then I will conclude by pointing to some lessons regarding antitrust in what I've called the hipster economy. So in the Google case, I'll talk about the issues involving Google search and some of the investigations in the US and the EU. Then I'll talk about the policy behind competition law review of search engines. And then I'll talk about the current case that's pending in the United States. So here's some factual background. Google search is a type of two-sided platform, as I described before. The way in which that platform is designed is that users can search for free. Advertisers, however, pay to support service in exchange to have users view their advertisements. So the search results trigger advertisements displayed on or near search engine result pages. So the Google features that have been added to its search function involve universal search that was introduced in 2007. Then they had ancillary services such as maps that was introduced a few years later. Then they would offer the ranking of the search results. And then they had a Panda update that was introduced in 2011 that would allow for direct purchase from the various sites that were the result of the search. So what were the competition concerns against this factual environment? One issue was Google's preference for own comparison shopping. Would Google give preference to its advertisers over other non-advertisers that were picked up by the search algorithm? Would there be design choices as a basis for competition law scrutiny? So is Google designing the search engine in order to favor advertisers, in order to make it more difficult for consumers to find the cheapest price or the best option? And even if it was doing this, would there be business justifications for these design choices? Finally, there are concerns about potential competition. Is Google foreclosing entry into the market? Is Google limiting potential competition by creating, for example, higher prices for advertisers, reduction in the quality of search results, and reduction in innovation and quality of the search functions? So one issue that comes up is how do you determine market power in the search area? One way is to measure the number of views. And so that's an 87% of views are coming up in Google searches. That's just an estimate. But is there power? How do you understand market power? Usually market power is understood in theory as an ability to have some effect on the price of a product or service in the market. So, there are some tests that are controversial regarding temporary changes in price and looking at elasticities. I'll be glad to take questions about those, but those are, I think people are familiar with the controversies. But they basically, involve looking at price. The problem, of course, here is there is no price. Users get this for free. And so to what extent then is this market power exist if within this two-sided market, the one side is getting it for free and the other side is paying to provide this advertising function? So one way is to gauge by quality, to look at the ability to degrade results in order to harm rivals. So this is recognizing that companies do not only compete based upon price, but they also compete based upon quality. And so we could equate a reduction in quality to a raising of the price of the product, at least in theoretical terms. So if you think about there being a shadow price, for example, for the product or service. Another way to gauge market power is to see whether, Google argues that it lacks this power because consumers can readily switch to another search engine. And so the question then would be, is there switching? Or are there fixed costs? Are there switching costs that make it very difficult for consumers to switch to another search engine? And then, of course, advertisers would also leave Google if the results were degraded. But of course, that depends upon other benefits that the advertisers might be getting by, for example, steering customers to them if Google favors certain advertisers, certain searchers over others. So what would be the reasons for market power, how that would arise and how I would gauge it? They could arise from information problems. Consumers cannot gauge whether results are degraded. Google has a bigger database and more powerful algorithms than competing search engines, so that it can better monitor consumers and try to tailor searches to what the consumers want. And then Google can provide auxiliary services that mask the degraded quality of search, such as Google Maps or other types of information services. So the US approach to the Google search services, the Federal Trade Commission closed its investigation in 2013, and its reasoning can be summarized as follows. The totality of the evidence indicates that in the main, Google adopted that design changes that the commission investigated to improve the quality of its search results, and that any negative impact on actual or potential competitors was incidental to that purpose. While some of Google's rivals may have lost sales due to an improvement in Google's products, those types of adverse effects on particular competitors from vigorous rivalry as common byproduct of competition on the merits and the competitive process that the law encourages. In other words, the FTC concluded that there were business justifications for the way in which Google was designing its search engine, and these business justifications trumped any potential harmful effects on competition. So the US finds pro-competitive benefits on net. Although there was some evidence of degrading search results, the FTC concluded product design is an important dimension of competition, and condemning legitimate product improvements risks harming consumers. Reasonable minds may differ as to the best way to design a search results page and the best way to allocate space among organic links, paid advertisements, and other features. And reasonable search algorithms may differ as to how best to rank any given website. Challenging Google's product design decisions in this case would require the commission or a court to second guess a firm's product design decisions where plausible pro-competitive justifications have been offered and where those justifications are supported by ample evidence. So we can compare this with the approach by the European Commission that reached a different result a few years later. In 2017, the European Commission found that Google abused its dominant position in general internet search by giving illegal advantage to its own comparison search services. Abuse of dominance includes applying dissimilar conditions to equivalent transactions with other trading parties, thereby placing them at a competitive disadvantage. Although the European Commission acknowledged the benefits of Google's design choices, the choices did not justify giving preferential treatment to its own comparison search service. However, no specific remedy was imposed. Google was ordered to redesign its search engine to avoid favoring its own comparative search services. So the general findings by the European Commission are worth considering. General internet search services and comparison shopping services are separate relevant product markets for the purpose of analysis. Google has a dominant position in general search. Google abused its dominant position in general search by conduct that decreases traffic from Google's general search results pages to competing comparison shopping services, and increases traffic from Google's general search results to Google's own comparison shopping service. The conduct is capable, the commission concluded, of having or likely to have anti-competitive effects in the markets for comparison shopping services and general search services. So, this suggests, various approaches that you could think about to exclusionary product design, such as the design of a search engine, or perhaps the design of a social media platform like Facebook or perhaps Twitter, though Twitter hasn't come under as much scrutiny as these other companies, or a retail platform such as Amazon. So one example is to look for things like a hard switch, to focus on whether a dominant firm coerces firms or consumers to adopt a new product. Some of that occurs, for example, through pharmaceutical marketing. You could have something like a no economic sense test. Would the conduct be a rational business strategy separate from harm to competition? And we sort of see that in the FTC, the approach of the US, this no economic sense test, though their approach, the FTC approach, is more deferential to the company, while this no economic sense test probably would apply or require more scrutiny. Finally, you can have a rule of reason approach, which is balancing of anti-competitive effects and business justifications, which probably is the best description of what is going on in the U.S., while the no economic sense test would probably be a good description of what's going on in the EU in the Google case. So just summarizing the EC and the US approaches, the EC has a lower standard for abuse of dominance, including discrimination against rivals. The US has generally very limited requirements for cooperating with rivals. And so you can see this in a discussion of the Qualcomm and Microsoft cases. However, note that US law does find discrimination against a rival as potentially anti-competitive. And there are two big cases: the Lorraine Journal case, where the newspaper violated the law by refusing advertising from companies that advertise with the rival radio station. So this is a case from the 1930s where a newspaper was getting a competitive threat from a radio station that was entering the market. There's also the Ottertail case, where an electrical company violated the law by refusing to transmit power to communities with their own power stations. So the US, on the other hand, emphasizes design choices that benefit consumers and promote innovation. And so they adopt what we can think about, as we described in the previous slide, as this rule of reason approach. So the US approach, focusing on business justifications to avoid deterring innovation. EC approach emphasized competition harms, even without empirical evidence of injury, to promote innovation and other benefits of competition. So more of a, as we saw at the very beginning, an arrow approach to how we think about the relationship between competition and innovation. Very quickly, let me talk about the pending US case against Google. So this was filed by the Department of Justice in October 2020, a week before the presidential election. So people were finding some sort of political motivations maybe for why this case was filed. But the basic issues here, and I'll be glad to take more questions about this because there's some controversies about whether the complaint is adequate or not. But it alleges monopolization claims against Google based on leveraging its operating system to require applications such as maps and direction services as a means to block other search engines. And this leveraging occurred with the iPhone, and the leveraging also occurs, of course, from the Android operating system that we see on those phones. So let's conclude by looking at some lessons for competition law and intellectual property, lessons for antitrust in this hipster economy. Lesson one, de-emphasize market definition for analyzing innovation and future price competition. We're not saying not to use market definition, but there's, as we know, there's a lot of controversy over market definition in antitrust law. And so we need to be very careful not to have too rigid a definition of markets as we try to identify what the effects are on competition. Lesson 2, probably rely on validated presumptions to assess innovation effects. Should we have a presumption that a concentrated industry is going to hurt innovation, and then push the burden on the company to prove that either that there are business justifications or that the innovation is somehow being benefited by their conduct. Lesson 3, courts should require benefits from proposed mergers or acquisitions. So this is a big area. This is the issue in the Facebook case. That complaint was just filed earlier this week by the Federal Trade Commission against Facebook. And as I mentioned before, the goal is to challenge acquisitions by Facebook of several companies, including Instagram. Lesson 4, courts should increase scrutiny of acquisitions that eliminate potential competition. So this is a corollary to the FTC action against Facebook. In that action, FTC seeks to undo an acquisition. But what lesson 4 is saying is that, basically scrutinize the acquisitions at the outset, so that we don't get into a situation that we're seeing with Facebook. And frankly, within the Facebook case that was filed, there is a lot of controversy over whether the FTC will prevail based upon its theory of trying to undo an acquisition. Lesson 5, courts should not require evidence of substantial foreclosure to prevent exclusionary conduct. And so here we're seeing a lesson that is more akin to the EC approach, that looks at more conceptual harm or potential harm, really trying to prevent harms occurring based upon an understanding of the market and how consumer choices are being affected. The US approach is, as we saw with Google, more deferential to the company, to the industry, and does require more substantial evidence of some sort of market harm. Lesson 6, compulsory licensing is often an effective tool to promote innovation, and we saw a little bit of that in our discussion of IBM, AT&T, and Xerox earlier on. Lesson 7, a truncated rule of reason can be a useful tool to assess allegations of anti-competitive innovation. So a truncated rule of reason will be something between the rule of reason that we talked about in the context of the Google case and the no economic sense test that arguably describes the EC approach. Lesson 8, antitrust authorities should evaluate the effectiveness of remedies for innovation. This is the most difficult part. What should the remedies be? And how are the remedies going to benefit innovation? We saw that a little bit in the Google case in the EC. There were no sanctions by the commission. Instead, Google was ordered to redesign its search engine in order to avoid some of the anti-competitive impediments to innovation that the European Commission found. Lesson 9, approach divestiture cautiously. Again, we're seeing this in the Facebook case. We see this in other cases where breakup of the company is a remedy. Divestiture basically is the fancy word for breaking up a company. And so, even in the Google case, there's talk about that being a possible remedy, though the remedy section of the complaint is actually fairly thin in my perspective in that case. But we need to be careful about breaking up companies because of the advantages of economies of scale and economies of scope. So the big challenge is, how do we align competition law and intellectual property for the goals of development? And this is something that I leave for you, especially for for scholars and academics that are coming from developing countries. I've spoke largely about the US and the EC experience, but the lessons there and the general theory that I've talked about are relevant for those economies. This hipster economy is spreading. It's not just something that simply exists in the developed world, but even if you look at developing countries, if you look at mid-level or developing countries, we're seeing obviously the presence of high-tech companies. We're seeing the presence of IT. We're seeing the presence of social media. We're seeing the presence of pharmaceuticals. We're certainly seeing this intersection between intellectual property and competition law. And so we need to think about how competition law would work in this spreading hipster economy. And so with that, I will end my presentation. I want to thank you. Thank you, Professor Khong. Thank you all for listening. If you have any questions, feel free to email me, and I'll be glad to share the slides as well if people are interested in these slides or any other work that I might have that you might be interested in. So thank you. And I'm going to stop sharing now.
Thank you, Shubha. We have some time for question and answer, so we open to everyone for any questions that you would like to address to Professor Ghosh, and let's have some discussion here while we have some time. While we wait for some, you could type your question in the chat box and we could read it out. So perhaps while we wait for some points of discussion, I was wondering whether, Shubha, your idea of a hipster economy translates into the issues right now that we are seeing, especially for Uber in the gig economy. Because I believe that Uber is facing some legal challenges, particularly in the West Coast, such as California.
Yes. Yeah, a lot of those issues they'll have to do mostly with employment issues. How do we treat how do we treat Uber drivers? What is their status? What is then the liability for Uber for the drivers and their activity? So much of that has to do with how we treat the workers. And so this is then related to the question of how we understand Uber itself as a company. Is it is it set up in such a way that we think about these drivers as independent contractors, or we think about them as employees? And there was a referendum in California. I think that's maybe what you're referring to, and that referendum, rejected the idea that Uber drivers would be treated as employees. Instead, they would be treated as independent contractors. But down the road, we can imagine, antitrust cases and competition cases that might arise. But at this point, we have not, seen those.
That's nice. Any questions from the other participants? Do you have anything to say about the latest news that I've read yesterday about the potential sale of Boston Dynamics to Hyundai? Because I would be thinking that this is a tremendous technology which would change us in the future. Wouldn't that be some kind of national strategic technology that the US government would prefer that to be kept in US and not being sent to another country?
Yeah, no, this is really interesting how this would play out. I think one of the things that obviously everything is being very closely watched post-election. I think it's very clear now. I think it was clear at the outset that we will have a Biden administration. You may or may not know President Trump has lost his most recent attempt to undo the election. And so the reason I mentioned that is The Biden administration probably will have a very different approach to antitrust law and how we think about the U.S. strategy. We don't know yet who Biden will pick for the Attorney General. There have been some interesting names touted, and we don't know specifically who will be in charge of the Antitrust Division. But following in the line of Biden, which will probably be very close to what we saw under the Obama administration, I think there would be more of a free trade, technology flow, technology transfer type approach to this merger. But then the question is, what exactly would be the competitive impact, the innovative impact? If I were to make a prediction about this, and this is where we get into some very interesting issues regarding things like self-driving vehicles and hybrid cars, electric cars. I think there would be a big analysis of what the effect of this type of combination would be on that particular source of innovation. So I think as far as the strategic aspect of this, it's very different, for example, when we were looking at, I think in the 2000s under the Bush administration, the Chinese oil company buying up oil companies in California, and that was blocked. I mean, that was hindered partly because of some of the strategic concerns over oil, as the commodity question there.
Yes. I think there was another interesting news as well, was Uber was giving up its autonomous vehicle division. I think Uber was initially one of those big players apart from Google that potentially, and Tesla obviously would be able to roll out a fully autonomous vehicle in near future, but it seems like was it because they ran out of funding and they have no choice but to sell the division, autonomous vehicle division, to someone else.
You're talking about Uber selling?
Yes.
I'm sorry, yeah, I think you cut out there a little bit.
Yes,
yeah,
Uber
I don't know
selling
exactly.
the autonomous vehicle division.
Uber's a controversial company. There's been a lot of scrutiny about its management style, and so I hesitate to talk too publicly, partly because I don't follow the company that closely, and a lot of these things are proprietary information. But my sense of that sell-off have more to do with internal management than it's a pure sort of corporate law type issue rather than competition concerns or intellectual property or innovation concerns.
Okay, I see.
Now I see there is a question. It's a challenging question in many ways, because the questioner is asking me whether I'm willing to take a bet. So I don't know if this is a metaphorical bet or an actual bet. So at the outset, I'm not a gambling person. I don't know, Dennis, what is the law in Malaysia about gambling? Would this be
we are now international. There is no clear applicable laws. and we even ask, where is Zoom? Is Zoom in the US or in China?
I think maybe next year, maybe this suggests next year you should have the conference in Macau, and therefore you can take as many bets as you want, So, but I will answer this question in a metaphorical way, though the speaker is perfectly free to contact me, and maybe if he has an interesting wager to make to me privately, I'll consider it. But publicly, I'll treat this as a metaphorical bet. But he's asking me about the outcomes of either the recent Google case or yesterday's new set of Facebook cases. So let me do the Facebook case first. I think that's the easiest. My prediction is that Facebook will prevail. I mean, I think this idea of, and again, we can then unpack that as what do we mean by prevail. But I think the government's theory here is one that's been, talked about a lot by scholars and practitioners, And basically they're trying to undo an acquisition that's 8 years old. It's almost a decade old. And there's some argument about whether they even have the power to do that under existing law. And then even if they do have the power to do that, the agency, the FTC having the power, uh, the question then is what the remedy would be. As they say, I mean, if it was an anti-competitive acquisition to begin with, then somehow you have to go back to where the market was in 2012, where you have Instagram as a company that's separate from Facebook. But how do you undo that? I mean, how do you get back to what the Garden of Eden was, if it was such a such an idyllic place in 2012? Given that you've had 8 years of the companies working together, uh, uh, and then sort of being intertwined in its operations in some way. So I think that for me is probably an easy one for Facebook. It'll be interesting to see how the Biden administration. I may be a minority here, but I'm of the mind that once Biden's administration is in place, the Facebook case might be re-examined. I mean, there's some reasons why it may not be, but I think it's a very controversial case. In some ways, it's a weak case because it's bringing such a radical theory, and so there are ways to maybe refashion the case, which would involve procedurally maybe withdrawing and refiling or amending the existing case so that it might have more theoretical heft to it. Now, as far as the Google case also, there was some concerns about how it was filed. Again, I don't want to cast aspersions on the U.S. government, even if it even but it seemed like it was very hastily filed because there seemed to be some fairly big theories that the complaint didn't raise. For example, it didn't raise any theories regarding tying. It didn't raise any of the kind of theories that we saw in the Microsoft case that were successful regarding the design of the software. So again, I think there's room for that case to be more successful than the Facebook case, because the Google case is relying upon some established antitrust theories that have already been tested and have some legs in the technology sector with the Microsoft case, for example. But the government did not push that quite a bit or at least not as much as it could have in its complaint. So I'm predicting that what will happen, again, predicting, not taking a bet, that once the Biden administration is in place, then that case will also be refiled and maybe the complaint will be a little bit stronger. Are there any follow-ups to that? Or I think there's one other question. So let me get to my concern is that the regimes on law and interaction on copyrights and patents. Would you mind introducing some relevant theories for limitation on IP owners? Okay. Well, that's a very interesting question. I could do another. I just spoke an hour about this. I could speak another hour on limitations on IP rights and what's the proper scope of IP rights and so forth. There is a sense that you do need IP rights, some degree of IP rights for invention and innovation and technological change and development. That the world, the economy would look very different if there were no intellectual property rights. So you might have diffusion of technology, but it might occur more through imitation. Innovation might be a little bit slower. There's to bring it into current terms, there is a lot of active debate now about whether assuming these vaccines for COVID are foolproof, and they seem to be. And so I don't want to doubt them. But, question is whether intellectual property rights were needed for those types of innovations. Well, there have been some patents that have been pursued in these areas, and there are existing patents on vaccines. There's some questions about the validity of those patents. So certainly patents played a role. I don't want to overplay the role, but they certainly played a role in the development of these vaccines. There are some questions about whether patents might limit the dissemination of these vaccines. I don't see that. I mean, I think there's just such a big demand for these vaccines. We are talking about something that's a blockbuster. That's even though technologically maybe it's not breaking any new barriers, but in terms of product demand and product need, it is a pioneer product. And so even without patent protection, there would be great incentives to disseminate and distribute these things. But I stand by the proposition that at least some minimal level of intellectual property protection is needed for even for dissemination here. So the question that comes up, the big debate is, how much is too much, or how little is too little? I think there's enough evidence that that patents and copyrights are often used strategically to foreclose entry of new products. So we see this in the pharmaceutical sector with several cases where the pharmaceutical sectors and the use of patents are there to limit generic entry. And again, those issues are very complicated. They're not just simply a matter of patents. They're also a matter of FDA regulation and other types of drug regulation. But nonetheless, we do see these anti-competitive uses of intellectual property, these strategic uses of intellectual property, as opposed to sort of the incentive, reward uses of intellectual property. And so we need to keep those in mind, and we need to think about limitations. So one of the reasons I spoke about exhaustion is actually an intellectual property law doctrine. But in recent years, it's spilled over into competition law with cases like Quanta. In fact, the Quanta case, is an interesting hybrid of intellectual property law and antitrust doctrine, in my opinion. And so exhaustion is an area where we can see there are limits on intellectual property in order to promote competition in aftermarkets. Whether it's the market for resale, whether it's the market for service, or whether it's the market for spare parts, or whether it's the market for repair, or the right to repair. So I could go further on that, and there are lots of discussions about beyond exhaustion. There's an active discussion in the copyright area about fair use. I believe there might even be a panel or some papers about fair use in this conference. But in any case, that's another area where we think about limitations on copyright in terms of actually promoting innovation, or at least limiting the ability of a copyright owner to block innovation. And then, of course, in areas like trade secret, you have the full doctrines like reverse engineering, which are very important doctrines for innovation policy, which are defenses to trade secret misappropriation claims. So I hope I understood your question and I addressed it. But there is this background of intellectual property that's important to understand when we're understanding competition policy. And so we shouldn't think about competition policy and intellectual property as enemies. And I think there is a symbiotic relationship between the two that's important to understand. Excuse me. So are there any follow-up questions or any further questions? Dennis, you need to unmute yourself.
Sorry, yes. So I see there was a question by Hugh Trong. Was that the question on limitation of intellectual property?
Yes, that's the one I just answered.
Okay, I see.
The one I attempted to answer.
Okay. In fact, since you were talking about the COVID, and I read in some academic discussions about the potential of using liability rules such as compulsory licensing, but are countries seriously thinking about that, or they rather go into direct negotiation with these big pharmaceutical suppliers? Because
yeah, I mean, compulsory licensing is we saw those examples. There tend to be very extreme remedies. And I think that's probably right. I think even in countries like India, we've seen a movement away from compulsory licensing. There's been some interesting research about how petitions for compulsory licensing with the Intellectual Property Rights Office have declined in the past several years. And I think the movement then has been to, as you described, more direct negotiation, maybe private-public partnerships. I mean, the problem that arises with compulsory licensing is, the problems of capacity, problems of manufacture, and problems of dissemination. How do you, coordinate all those aspects of the market? And that does require more extensive negotiation, as well as, I think, more involvement by government agencies or other players in order to make sure that not only that the new drug does get licensed for manufacture and sale, but also that it is in fact manufactured and distributed. Because that can also be quite a challenge. I mean, that's what we're seeing. I mean, right now in the United States, dissemination is through, like with many vaccines, it's through hospitals, it's through apothecaries, it's through drugstores, the equivalent of drugstores, like the Boots that we have. I forget what the drugstores are called in Singapore and Malaysia. Do they have Boots there? Or anyway, but the equivalent of those in the U.S. And of course, universities. My university, Syracuse University, offers extensive testing. Many of the big universities, Cornell, University of Illinois, offered extensive testing of students and faculty. And as soon as the vaccine is approved and the channels for dissemination start expanding, I'm sure that they'll also start offering vaccines. My university, for example, already offers the influenza vaccine every year in the winter, in around November or so. So I would not be surprised if sometime next summer or maybe next fall or maybe as even early as April or maybe March, it will offer the COVID vaccine. So I think I may have lost track of your question, Dennis, but I think I hope that addressed it.
Yeah, yes. Is there any other questions from the participants here? So if we don't have any questions, we should end the session. Yes, there is. Cookie, all right, yes.
Okay.
Yes, please.
Okay.
Professor, all right.
Thank you for your great presentation, Professor Ghosh.
Yes,
in your
thank you.
presentation, the result of the econometric empirical analysis were fully presented, especially in relation to innovation and competition. On the other hand, in the Google and Facebook lawsuits, economic analysis is still a work in progress. How do you think economic analysis will be used in the future? Thank you.
Yeah, no, that's a great question. I mean, I think a lot of the ways the economic analysis is being used now is in the decision to bring the case, so that the economic analysis is used to somehow formulate the case and thinking about identifying what the competitive harms would be. And that's true on both sides, so that Google and I'm sure Facebook, I know Google does, but I'm sure Facebook are also modeling its market position and trying to understand the business justifications in economic terms for its practices. So often these are done outside of litigation in order to identify either the harms or the business justifications, and then translate that into legal language. And so there will be expert economists that will be introduced depending upon how far the case progresses. I mean, if you go back and look at the Microsoft case, there were experts that were brought in to explain, for example, the network effects, to explain, what the the effect of the tie between the browser and the operating system was, how those contractual requirements operated, and so forth. And so there will be economic experts. I don't know where exactly this will go. As I say, with the Facebook case, it is such a new theory that there'll be a fundamental just legal question as to whether the agency even has the authority to do this. It did look at the economics of the acquisition back in 2012, and the agency approved it. So essentially what FTC is trying to do is reopen that case. And so there have to be some legal basis, which ultimately would be a basis in the economics, identifying economic or competitive harms for reopening that case. So one argument has been that Facebook actually knew about these harms, so that it was actually intending to act anti-competitively. And so that might give the FTC some authority to reopen the case, maybe based upon some unclean hands or improper conduct by Facebook, or on some novel theory based upon its intent, maybe fraud on the FTC. I think all of these theories are fairly new because we haven't seen examples of a government agency undoing a merger so far after it's been approved. In the Google case, as I mentioned, there are more legs, there's more substance, but I think I really do think the complaint could benefit from some more legal analysis, as well as some economic support for some of the harms that are being asserted there.
Okay, as an academics of law and economics, we are very interested in how economic analysis will be used in litigation. Thank you very much. I really appreciate it. Thank you.
Thank you. Thank you.
Thank you. Any questions? Any other questions from someone?
Somebody suggested that Facebook should raise laches as a defense. Maybe. I'll have to think about that. I don't know how laches works in this particular context, or would work in this particular context. I guess the theory is that seems like it would be more of an estoppel theory, that that the FTC had its opportunity to identify the anti-competitive harms back in 2012, and therefore it's stopped from rebalancing those, rebalancing the pro-competitive and anti-competitive effects. Again, I think it rests upon whether the FTC has some new evidence of harm or some evidence of intent, so forth.
Okay. Well, if there is no other questions, perhaps we would like to invite everyone to turn on their webcam and let's have a group photo.
And so I want to thank you again, Dennis, and thank you for all the participants for your patience. I hope it was interesting, and please keep in contact. You have my email address if you would like to follow up.
Yes, thank you. Thank you very much, Shubha. Okay, I think everyone who wanted to turn on is here. Do we have anyone else? So if not, I'm going to take, so, okay, great. So, okay, I'm going to take the picture. 1, 2, 3. Another one. Okay, great. Thank you very much for the great sharing on antitrust in a hipster economy by Shubha Ghosh. So we have 20 more minutes before the next session begins, and what we are going to do as usual is to invite everyone back to the waiting room, and you can have a break, and once the time starts, we will invite everyone back here. So thank you very much again, and see you later. Bye.
Thank you again. Have a good conference.
Thank you.
Thank you for your attention. Bye.